ASWB social workers. In this video, I am going to do somewhat of a 2.0 version, shorter version on subpoenas versus court orders to clarify some things as well as some new information that I feel like will be more relevant to helping you to navigate the questions on the exam in regards to subpoenas versus court orders. So if you have not checked out my first video, go ahead on and type that in the search bar and check that one out first. That one is going to be more in-depth, more conclusive of information that's necessary. This is just some additional information, like I said, in regards to some questions that have been coming up. So I want to shed a little more light on that. So getting started, jumping into first understanding the difference between a subpoena versus a court order. This is definitely where you need to start, because if you don't know the difference between the two, you're not going to appropriately understand the way to respond to each. So a subpoena is a legal document that requires a person to appear in court, give testimony, or produce documents. It is typically issued by an attorney or a court clerk, not necessarily a judge. That is going to be important for you to remember. A subpoena is typically issued by an attorney or a court clerk. Now, your obligation as a social worker to respond, you must respond. So it's not like you can just ignore it. However, you can object. So when I say must respond, that means you can't just ignore it. You have to say, yes, I'm going to give this information, or no, I'm not going to give this information. You have the option, but ignoring it is not professional, nor is it an option. You do not automatically breach confidentiality, right? That's something we do not do. You want to consult with legal counsel before complying if you feel like that is necessary. And legal counsel a lot of times will apply to if you're working in private practice or you're working in an agency where you don't have supervision or higher ups. Then you want to seek legal counseling. You may need consent or an actual court order to release certain records like therapy notes. Okay, so you may need the client's consent or a court order to release certain records. It depends on what's going on, but the key here is to know that you are not obligated to do so. Now, a court order is a directive from a judge that requires a person to do or not do something, such as produce documents, testify, or release records. Of course, this is going to be issued by a judge. Your obligation to respond as a social worker, you must comply. Okay, not just respond, but you must comply. This is enforceable by law. This overrides confidentiality rules in most cases, and your failure to comply can result in legal consequences, like being in contempt of court. So let's just recap real fast. A subpoena is typically issued by an attorney or a court clerk. You must respond, but you can object. A court order, hence court, is issued by a judge and you must comply. Now we're going to get into the part of complying to a court order when you feel like there may be information that is irrelevant to what's going on or may harm your client. This is going to be referred to as a protective order, a legal request asking the court to restrict access to certain information or allow only partial disclosure when full disclosure may either harm your client, breach their confidentiality, or reveal sensitive or irrelevant material. So an example of that would be, let's just say that the client has gotten into a new situation where, I don't know, let's just say he robbed someone, right? And he was in therapy for anger management after maybe he brutally attacked someone years ago due to, him being assaulted as well, and all kind of things came up in therapy, and you feel like that has no bearing on the situation that's taking place now, and you know that some of the information in your notes that the client maybe have revealed to you is going to breach confidentiality with that previous situation or harm the client's credibility in this current situation. This is an example of when you would want to file for a protective order. The purpose is to protect that client's privacy, to prevent unnecessary harm, and to limit disclosure to what's essential and legally required, especially for the situation at hand. Now, how this works, you receive a subpoena or a court order requesting records or a testimony. You review the requested information. If some parts are highly sensitive or irrelevant or may harm the client, you want to consult with your legal counsel immediately, your supervision, whether that's the legal people in the agency. You want to do that immediately. Why? Because your attorney can file a motion to quash the subpoena, which could be to void it altogether, a motion to modify it, which means to narrow the scope of what you're providing, or a motion for that protective order to limit access or allow redacted summary information. Okay, so a lot of times, this is also something that the social worker, could do in reference to like the protective order, to try to limit the access. I would definitely recommend the legal way. But also, you should know that the judge is going to review whatever motion is submitted, and he or she is either going to approve it or limit the disclosure, or say, no, I asked for what I asked for, I need it all. And whatever the judge's decision is, from that point is what you have to comply with. Now, of course, for the ASWB exam, the questions don't go into that full extent, right? But I feel like if you understand how the full picture works, it will help you better understand how to answer the questions. So now, just basically knowing that if the question is giving you a situation where it's coming from the attorney of the opposite party, if two people are going through a divorce or a custody battle, and the subpoena comes from the other person's attorney, you do not have to comply with that. You have to respond, but you don't have to comply with that. You can consult with your client on if you want to release any information at all, what information that you want to release. So just remember that. Now, here's another example scenario. You're a therapist in private practice and you receive a court order, not a subpoena, requesting your full psychotherapy notes. You know that this full release could harm the client emotionally and or reveal irrelevant, sensitive personal history. Let's keep in mind that this is a court order. This is not a subpoena from an attorney. This is coming from a judge. So what you would do, especially because you're in private practice, you would want to consult with your legal representative and have your attorney to file that motion for a protective order so that you can request that only a summary of the progress notes be released. Not every single progress note, that only that the sensitive content can be redacted. So that means you can submit notes, but taking out or not providing that sensitive content that you feel like is going to harm your client emotionally, or reveal any irrelevant personal information. Or for the judge to conduct an in-camera review to decide. Now, we don't see this option too much on the exam. An in-camera review is just a legal process where the judge reviews the sensitive records privately in his chambers and not openly in court. So from that, the judge decides what, if anything, can be disclosed and to what extent. So you can do an in-camera review and the judge will sit there and just kind of, go through the stuff himself. and decide what needs to be revealed publicly in court, since you are saying that, some of it is irrelevant, some of it is too sensitive, and things of that nature. So now we're just going to look at this practice question to kind of hone it all in and to create a little more clarity with some questions that I've been seeing that are similar to this issue. A social worker is providing therapy to a woman who is going through a divorce. The husband's attorney issues a subpoena requesting the client's treatment records. What should the social worker do first? Of course, this is a dilemma. This is in regards to client's records, so we know this is ethics, even though it's a first question. The first is just telling us that we need to be doing what's most important about the priority problem in this situation. So looking at this, you're a social worker and you are providing therapy. So that automatically lets me know, I'm already working with this client to this woman who is going through a divorce. That is what her presenting issue is. Now, the priority issue here is that the husband's attorney. Now, we're going to be heavy on the husband's attorney, not the judge, issues a subpoena, not a court order, requesting the client's treatment records. What is the most important thing that you as a social worker should do when the husband's attorney issues a subpoena requesting the client's treatment records? A, release the necessary records to the attorney. That is not going to be the very first thing or the most important thing that we're going to do, because we already just talked about that we first want to we need to first see, a few other things before we just say, oh yeah, sure, I'm going to send the records. So we know that one's not going to be the most important thing that we do. Refuse to release the records. That is something that we could do. So we're going to put a pause on that. Is that the first and most important thing we need to do in this situation? Again, it is very possible. So we're going to pause that. C, call the attorney to discuss the matter. Now, we just talked about that as well. But we're also going to keep in mind that there is nothing in here, and we're not going to assume that is saying that there's information that's going to harm the client or whatever. If the question doesn't include that, we're not going to assume it. But however, we can still pause it to see if that would be the most important thing to do in this situation, if we need to call our attorney, since this person's attorney is contacting us for records. And D, contact the client to inform her of the subpoena and discuss next steps. So this is also something that I feel is plausible that we could also do in this situation. Now, here is a common question where people get confused on, okay, so which one do I need to do? Because yes, we can do all of these, right? So you're going to look at what is the most important thing to do. The other thing I want you to do is keep in mind more of a here and now perspective of what you would do, kind of in this situation as a whole. So this doesn't say whether this is a phone call or whatever, because subpoenas usually don't come via a phone call. So I want to put that in your mind as well, because someone brought that up in a group session of some time ago. So usually you're not going to get a subpoena over the phone. It's usually going to come, by way of writing, by mail or something like that. So keep that in mind. So most people are saying, oh, I'm not just going to hang up in their face or in the moment, I'm just going to refuse and tell them I'm going to call them back or whatever. A subpoena is not going to be a phone call. So that's the first thing that we need to understand with that. So now, are we refusing to release the records? Are we going to, once we get this in our hand, let's think of it like that. Once we get it in our hands, are we going to just say, you know what, nope, I'm just going to reply back, because we know that we have to reply, but we have the option to object because this is only a subpoena. Are we just going to refuse to release the records? That's an option. I have the subpoena in my hand. Am I just going to pick up the phone and call my attorney and see what it is that I need to do? Right? Or am I going to contact the client to inform her that I received this subpoena and see what the next steps are going to be? All right. So when we look at it like that, in the here and now, we receive the subpoena, it's in our hand. When A social worker receives a subpoena, remember. We're not automatically required to release those records. It's just a legal request, not a court order. So in this case, the social worker's first step should be to not refuse to release the records or call the attorney to discuss the matter. We're going to contact the client, right? Because I just got this in the mail. I want to inform the client that this came in. So before I call the attorney to see what to do, I want to contact the client to see what the client wants to do, because hey, it may be something that the client wants released that could possibly help her case. Let's just say it's a domestic case, and she wants to prove emotional abuse or whatever, where her records will help that. So if I just flat out refuse to release the records, then that could go against what's in the best interest of the client. If I call the attorney to discuss the matter, and the attorney tells me not to release the records or whatever the case, that could be a whole different situation, and we definitely don't want to prioritize the attorney over the client. Now, there are some situations, depending on how the question is written and depending on the options that they give you, that's what makes this so tricky, because sometimes they'll write the question in a different fashion, or they'll give you different options. They won't give you all of these options at once. So you just have to be keen on how the process works, because there are some questions that you just flat out refuse to release the records, especially if they don't give you an option to contact the client. Like if it's some kind of question that will say something is being requested over the phone, yes. Now, granted, I don't know what subpoena is requested over the phone, but if it's anything like, if I have seen questions where it says the let's just say the husband's attorney calls and asks for this information. In that case, you will automatically refuse right then and there. Then you can call the client and say, hey, such and such called and they're asking this information, or they're asking about this. I didn't give them anything. Of course, I refuse in that moment, but what do you want to do now moving forward? Do you want to call them back and release this information? Do you want me to respond? How do you want me to respond? So if it's something like that where somebody's calling you for some information that is probably going to be outside of an actual subpoena, I mean, those things happen as well. There's questions where husband called for information about appointments and things like that. Instead of you just refusing to tell them, there are other ways you go around that. But nevertheless, getting back to this, the client has the right to consent to or contest the release of this information. If the client wants to oppose it, the social worker may then need to consult with legal counsel or the court to determine how to proceed. Only a court order compels the release of records without client consent. I definitely want to stress that. Now, why D is better than B? Because I know some people will say, well, we just, want to assert privilege to the client. Excuse me. So we are going to refuse to release the records outright, right? Remember, a subpoena is a request, it's not a command, but it still requires a response. I'm going to stress that. Flat out refusing to release the records without first consulting to the client could create legal and ethical problems. The client is the holder of the privilege. Remember that. So we want to assert client privilege, yes, but just remember that the client is the holder of that privilege, not the social worker. So the social worker needs to inform the client and give them the opportunity to consent to the release or contest the subpoena, often going through their lawyer most of the time, or if they're wanting you to take other appropriate steps. So in this case, the best practice would be to inform the client. This is going to respect both confidentiality and the legal process. From there, you want to determine with that client the next steps based on what it is that they wish and whether a court order is eventually issued. So even if the client is not wanting to release certain records, a court order may eventually follow, and then you cross that bridge when you get there, remembering what you know about court orders, that you must comply, but there are ways that you can still assert privilege to the client by doing that protective order. If the client does not consent and no court order follows, then the social worker may refuse to release the records. But it's usually not the first step unless they don't give you the other option to contact the client, right? So if you get a subpoena, go ahead and contact the client and let them know what's going on and see how they want to proceed, right? Just remember, a subpoena is usually not going to be a phone call, and that's what I think people be, confused because they're being here in the now, being in the here and now. If you're in the here and now, then I want you to see a subpoena or a court order as a piece of paperwork, a document that is in your hand. If somebody's calling you over the phone asking you for information, yes, you are going to in the moment refuse it over the phone. And then you can ask them to submit their request in writing. Then you can ask them, I can't do this, but you can send me a request in writing. That is still not acknowledging or not acknowledging that the client is even in service. Is just saying, hey, whatever you're talking about, we don't take these kind of requests over the phone. You can submit it in writing. So there is that. Hopefully this clears this up. If you have any questions, leave them down below in the comments. Anybody in the comments that have any answers to the questions, feel free to answer them. We're all in this together to help each other out. But again, I wanted to bring this to your attention because I noticed that a lot of people are still struggling with the subpoenas versus court orders questions when preparing for this ASWB exam. Again, if you need any follow-up resources, practice questions, coaching sessions, and organized study system, you can find it all on my website at www.savvysocialworkerexamprep.com. I try to cover all the bases. My material does cover all levels of the exam. So hopefully you can head on over there to the website after you give this video a thumbs up. Share it with who you feel needs to know as well. And again, thank y'all for being here. Thank you for your support. And let's continue to get those passes the savvy way.